If you were to make this decision to overturn Chevron, would you consider the implications on all of the cases in the U.S. and the rules and the uncertainty that it would create?
Goodness, Senator, yes.
And would you overturn it? Is that what this means when you talk about maybe it's time to face the behemoth?
Senator, my job as a circuit judge is when I see a problem, I tell my bosses about it, like any good employee. And my job there, as I conceived it, was to say, hey, listen, look at some of the implications, the real-world implications of what we're doing here.
Okay, but you would be the boss if you were the Supreme Court justice. And what rule do you think should replace it? Should we have de novo review? Is that better? What do you think should replace Chevron deference?
Senator, I don't prejudge it. I can tell you what did pre-exist it was Skidmore deference, which was an opinion written by Justice Jackson, actually. That's what pre-existed. So there was deference before. And we had the administrative state for 50 years. And agencies would issue rules and decisions. I don't know what all the consequences would be. And I would pledge to you, I wasn't thinking about being a Supreme Court justice then. Mm-hmm. I was identifying an issue for my bosses. If I'm so fortunate as to become a justice, I would try and come at it with as open a mind as a man can muster. And I would tell you, I'd remind you, what I bear in mind, it'd be David Sentel. When I was with him as a law clerk, issued a panel opinion at the beginning of my year with him, going one way, and then by the end of the year, wrote for the en banc court, the full court, reversing himself. Now, some people think that doesn't show a lack of sufficient steel. I think that shows an open mind and a lack of ego that a judge should bring to bear when he or she puts on the robe, and that's what I would commit to you.
Okay, let's go to another piece of this philosophy, and that's originalism. And in other words, whether words and phrases in the Constitution should be interpreted according to their original public meaning or how the founders and their contemporaries would have understood them. Regardless of whether you characterize yourself as an originalist, you've applied originalism in several decisions, including last year in Cordova v. City of Albuquerque, where in a separate concurring opinion you described the Constitution as a, quote, carefully crafted text judges are charged with applying according to its original public meaning, which are the buzzwords for originalism. Criticisms of the principles underlying originalism are not new. In fact, I believe some lines from Chief Justice John Marshall's opinion in McCulloch v. Maryland in 1819, almost 2 centuries ago, are still relevant to our discussion of the point today. He wrote that the founders must have intended our Constitution to endure for ages to come, and consequently to be adapted to the various crises of human affairs. He continued, to have prescribed the means by which government should in all future time execute its powers would have been to change entirely the character of the instrument and give it the properties of a legal code. It would have been an unwise attempt to provide by immutable rules for exigencies which, if foreseen at all, must have been seen dimly and which can be best provided for as they occur. He added, if we apply this principle of construction to any of the powers of the government, we shall find it so pernicious in its operation that we shall be compelled to discard it. Do you agree with the point that Justice Marshall made in McCulloch?
Well, Senator, I would certainly agree that the Constitution must endure and that it's a lot bigger than any of us. And it will live in that sense, hopefully, a very great deal longer than any of us, our children's children. I do think it's important to try and understand law according to its original understanding, public meaning. Words have meaning. So
you don't agree with McCulloch about adapting to the crisis of human affairs?
No, Senator.
So you do agree?
I'm trying to answer
I just want a yes or no, that's all.
Well, I think it takes, these are complicated things that take more than a yes or no, respectfully. And what I would say is the Constitution doesn't change. The world around us changes. And we have to understand the Constitution and apply it in light of our current circumstances. That's what we're trying to do as judges. So, for example, one of my favorite cases in this area is Jones, right? Supreme Court of the United States is faced with a GPS tracking device attached by the police onto a car. Is that a search? And the court goes back and looks at the time of the founding what qualified as a search and found that that would have qualified as a trespass to chattels and a search by the government. And says if that would have been offensive 200 years ago, that sort of thing, it has to be offensive now. The Constitution is no less protective of the people's liberties now than it was 200 years ago.
So when the Constitution refers like 30-some times to his or he when describing the President of the United States, you would see that as, well, back then they actually thought a woman could be president even though women couldn't vote?
Senator, I'm not looking to take us back to quill pens and horses and buggies.
But just if you could answer that question, it's pretty important to me.
I'm trying to.
Okay.
Of course women can be president of the United States.
Okay.
I'm the father of 2 daughters.
Great.
And I hope one of them turns out to be president of the United States.
Okay, that's wonderful. How about like the Air Force? I agree with you. That's good. So in that case, you say, well, we can't take it at its literal words. So then the Constitution also says Congress has authority to oversee the land and naval forces, but there's no mention of the Air Force. And I assume you believe that would also include the Air Force because if they knew an Air Force existed, they would have included the Air Force back then.
Senator, I think the generals of the Air Force can rest easy.
Okay, great.
Let me give you
How
another.
about Virginia? Let's keep going here because I'm almost out of time here. In United States v. Virginia, the court held that the Virginia Military Institute violated the Equal Protection Clause of the 14th Amendment by excluding all women from VMI's military training. In his dissent, Justice Scalia stuck to his signature originalism and criticized the majority, saying the decision is not the interpretation of a constitution, but the creation of one. Is the interpretation of the Equal Protection Clause in U.S. v. Virginia consistent with the original public meaning?
And the majority in that case argued that it was.
Okay.
And the majority said that the words equal protection of the laws, whatever the secret harbored intentions of the writers, had an original public meaning that's quite radical and significant. And that was what the majority of the Supreme Court of the United States held.
So would you agree then that when you look at other things, would you be willing to apply this same approach to equal rights for minority groups, women, LGBT, including transgender people, racial minorities, the same approach you use when we argue, when you just made the statement about the he and his in the Constitution, about the not having the Air Force, about the Virginia military decision?
Senator, a good judge applies the law without respect to persons. Okay. That's part of my judicial oath.
So do you see it as your textualism, the original public meaning then? Would you apply it to these other contexts as well that I just mentioned?
And Senator, what I'm trying to say to you is I don't take account of the person before me. Mm-hmm. Everyone is equal in the eyes of the law.
Okay, I'm just trying to figure out this, because I think for some things, a lot of people who subscribe to this theory, they say it, well, we can have originalism for some cases, but not for others. And I call it selective originalism. And it just seems to me when you look at some of the opinions that use originalism that you have and some don't. Well, Senator, but I have one.
Senator, if I might just respond to that. I'd ask you to take a look at Jones again. Kylo, search of a home using a heat-seeking device. I'd ask you to maybe take a look at Crawford, the right to confront witnesses. Mm-hmm. Maybe as well the Apprendi and Booker line, written by Justice Stevens, a very originalist opinion about the right of an accused to be able to have all of the elements of an offense that increases his sentence tried by a jury of his peers. Those are all what one might characterize as originalist opinions protecting individual liberties.
You know what? We could do it on the second round. That'll be good. Just some minor things here at the end. When the Supreme Court temporarily blocks a lower court ruling, they need 5 votes. A practice known as the courtesy fifth has developed, in which a fifth justice will provide the vote needed to stay the lower court ruling, even if that justice might not have otherwise been inclined to do so. Do you think the practice of the courtesy fifth is a good thing?
Senator, I haven't studied that. It'd be presumptuous of me to offer an opinion in a court that I haven't sat upon.
Okay. Well, it may be very relevant when this refugee case comes up, so you might want to study up on it. I'm going to end here with, I'm going to do a lot of work on antitrust in the next round. I know you're an expert. Senator Lee and I have been heading up that subcommittee for a long time, but I'm going to end with freedom of press in honor of my dad. He was a newspaper reporter his whole life, and I'm especially concerned in today's world where we're seeing these attacks on the media about maintaining the press's role as a watchdog. Our founders enshrined freedom of the press in the First Amendment. As Thomas Jefferson said, our first objective should be to leave open all avenues to truth, and the most effective way to do that is through the freedom of the press. In New York Times v. Sullivan, the court issued a landmark ruling in support of First Amendment protections for the press by affirming that when newspapers report on public officials, they can say what they want. Maybe we don't always like that, but they can, unless they say something untrue with actual malice. Do you believe, under New York Times v. Sullivan, that the First Amendment would permit public officials to sue the media under any standard less demanding than actual malice? And can you explain to the people here today and those watching on TV what that standard means to you?
New York Times versus Sullivan was, as you say, a landmark decision. And it changed pretty dramatically the law of defamation and libel in this country. Rather than the common law of defamation and libel, applicable normally for a long time, the Supreme Court said the First Amendment has special meaning and protection when we're talking about the media, the press, in covering public officials, public actions, and indicated that a higher standard of proof was required in any defamation or libel claim. Proof of actual malice is required to state a claim. That's been the law of the land for, 50, 60 years. I could point you to a case in which I've applied it, and I think might give you what you're looking for, Senator, in terms of comfort about how I apply it. Bustos versus A&E Network. It involved a prisoner who was concerned that he had been misrepresented as a member of the Aryan Brotherhood. Claimed he wasn't a member, just a fellow traveler, and sought damages for that. Our court declined to grant that relief, saying that substantial truth is protected, even if it's not strictly true, and much more is required by the First Amendment in order to state a claim.
Okay, in Brandsburg v. Hayes, Supreme Court case, they didn't recognize the reporter's privilege, at least in the context of criminal grand jury testimony. Could you just end here by talking about the scope of the Brandsburg decision and whether there are instances where courts should recognize a reporter's privilege?
Senator, I know those cases come up from time to time, so I have to be very careful. But your description of the case is entirely accurate.
Thank you very much.
Thank you.
Okay, before we recess, I'd like to enter into the record a commentary in the Chicago Tribune called Crying Wolf over Neil Gorsuch, written by Dennis Hutchison, a lifelong registered Democrat. He specifically talks about concerns over Chevron deference. He writes, quote, "There are two sides to deference, however. My guess is that pro-Chevron advocates will soon be begging federal courts not to defer to interpretive findings of agencies," end of quote. Enter that in the record without objection. We will recess for 10 minutes, so that means we'll reconvene at 3:31.
March along, sing a song with the army of the free. Count the brave, count the true, who have fought to victory. We're the army and proud of our name. We're the army and proudly proclaim.
All right, folks, for the confirmation of Neil Gorsuch, that's it for today. It will continue tomorrow morning around 6:37 a.m. Pacific Standard Time. And then after that, we will be doing another Sean Spicer presser. So stay here with us at Golden State Times. Thank you very much, everyone, for joining us and choosing us as your stream of choice. And thank you to all the moderators that came out. I just wanted to show you guys real quick the end of it. If you missed any of the confirmation hearing for today, one part is on the channel. The second part, which is this, will be uploaded soon. So check it out. If you missed the presser, it should be uploaded on the channel. And stay tuned. Later on, we'll be uploading some videos. Thank you very much, everyone. If there's any more live streams, we will be doing that later on today. Unless you guys want to check out the Senate floor debate. Let me know in the chat if you guys want to check out the Senate floor debate, and we can continue that. But thank you very much, everyone. Peace.